Hello and welcome to 40 Fit. My name is Victor Nyebado and today I'm joined by Lucia.
You're welcome.
And this is the very first edition of 40 Fit. 40 Fit is a podcast where we hope to take salient and topical issues that are related to carriage of goods by sea, break them down into very relatable forms that people who play in that value chain will find extremely useful. By that I mean importers, exporters, and anyone who happen to interact with them, people who advise them, people who act as agents to them, freight forwarders, clearing agents. All of such people will find 40 Fit a very useful podcast to tune into. Today we have a very interesting topic that I'll let Lucia introduce to you.
Yeah, so our topic for today is compensation for loss or damage to cargo. Now, say you import a cargo of sanitary wares from Madrid, Spain into Lagos via the Apapa port. Now, at the point of inspection, you discover that maybe a certain percentage of the cargo has been damaged or lost. Saying that the carrier should be liable is a righteous assumption because ordinarily, if I put you in charge of transporting my cargo from one destination to another and the cargo is in your custody, whatever happens to it, you ordinarily should be liable for that. Realistically and in practice, actually, it depends. It depends. So is that it depends? That is the basis of this podcast.
Yeah.
Now, when we say it depends, there are two things that will come into play. The contract of carriage, which is typically the bill of lading, and the applicable liability regime. Now, when you say contract, let's talk about the bill of lading, for instance.
Many people who play in this market appreciate the fact that the bill of lading is a very important document. In fact, for most people, it is the ticket that will unlock the warehouse of the carrier. However, the bill of lading also plays a much more important role in my mind, which is that it is the contract, the very basis upon which that carriage transaction was undertaken. And therefore, if there is loss or damage to the goods that were the subject of that carriage, a court of law and an arbitral panel will simply not just overlook what the bill of lading says in relation to liability of the carrier.
Are there instances where the bill of lading is silent on liability of the carrier?
Well, typically you wouldn't find that in most bill of ladings that are being used. But why you will not find that is the reason why the second point that she made, the liability regimes are applicable. It is those liability regimes that have compelled parties who enter into this bill of lading transactions to provide a minimum benchmark of liability for the carrier where he is found to be ordinarily so liable. So historically, there used to be a time in history where carriers would simply exclude all liability and say that, look, irrespective of what the cost might be, they will not be liable. So we had a situation of irresponsible carriers. Because of the tendency of carriers to do this, the liability regimes came to apply by force of statutory provision that this is the minimum benchmark of liability that you will have to take if certain things are seen to be the case. And I guess that's the point where I'll leave you to talk about some of these liability regimes.
Yes.
There are two that we know that are typically applicable in Nigeria.
Yes, we have the Hague Rules and the Hamburg Rules. Now, the Hague Rules apply in Nigeria by virtue of the contract, the Carriage of Goods by Sea Act of 2004, which applies to outbound cargo. We'll come back to this to explain exactly what we mean by outbound cargo. And we have the Hamburg Rules, which applies or operates in Nigeria by virtue of the United Nations Convention on Carriage of Goods by Sea Restitution and Enforcement Act of 2005. Now, this 2005 Act applies to inbound and outbound cargo.
In Nigeria, the Hague Rules that Nigeria domesticated applies to outbound cargo, outbound shipment. But of course, the Hague Rules can also be held applicable to your particular bill of lading because your bill of lading says it should apply. So it is not being applied whether your shipment is outbound or inbound. It could be inbound and held to apply because your contract says it should apply. So all that the court will be doing in that circumstance will be to interpret your contract and apply what you have bargained to you.
Yeah.
So that's the Hague Rules.
Yes. So just in addition to what he says, that's what is typically known in law as party autonomy, giving effect
to the bargain of the parties.
Exactly. Having established that at the point of taking possession of your cargo, you've discovered that it is damaged or a certain percentage of it is lost. So what are those steps that you need to take to enforce your rights? To hold the carrier liable for such damage or loss?
Excellent question. So the Hague Rules can apply because Carriage of Goods by Sea Act of Nigeria 2004 applies. It can also apply because your contract says it should apply. The Hamburg Rules, on the other hand, can also apply because Nigeria has ratified and domesticated it. So irrespective of what you agree upon, the law might be interpreted to apply to you compulsorily. So we want to look at the provisions of these rules, therefore, in a holistic manner, so that whichever one is held applicable to you, you'll be on the right side, you'll be in good stead to have your liability claims successfully prosecuted. So the question you ask is, what are the steps that you should take in order to ensure that you have successful claims? Number one, issue a demand, a notice that your goods have been damaged and demand for compensation. Both regimes require for that notification to be made. But the time within which you should make that notification becomes something that has several other ramifications. So in the case of the Hague Rules, you should notify the man before, at the time of taking delivery, or if the damage is not readily apparent, within 3 days. So notification is important. So I've mentioned that in the Hague Rules, you should do that at the time of taking delivery, before that time, or within 3 days if the damage is not readily apparent. The Hamburg Rules gives you 1 day to do your notice of damage and make a demand for it. The second thing is the time within which you should commence your claim. So there's this thing called cause of action. You want to explain what the cause of action is?
Cause of action. Now, we've mentioned the notice of damage.
Yes.
Cause of action is typically when your right to sue has arisen or crystallized.
Excellent.
Now, at the point where you issued that notice of damage, it is deemed that your cause of action has arisen. You've discovered this defect, you've discovered this that your cargo has been lost, and now you've taken steps, you've initiated steps to demand for compensation based on that loss or that damage.
So your cause of action is basically, guy, you have lost or damaged my cargo, pay me. If he pays you, there's no need to go to court. If he doesn't pay you, then the Hague Rule says you must go to court within 1 year. If he doesn't pay you, the Hamburg Rule says you can come to court within a space of 2 years. So if I were you, what would I do? I would bring the case within 1 year. If you bring the matter within 2 years, and indeed we have had situations where actions were brought within 2 years, and the courts have simply held that, look, it is started bad, the court will have been brought within 1 year. So irrespective of your argument that the Hague Rule applies or that the Hamburg Rule applies, I think that you'll be in a safer position to bring that action.
It's important to be very proactive at the point where you issued your notice of damage. Once you've observed that maybe you're not really getting the feedback that you need, it's really very important at that point to involve a lawyer and not wait till the expiration of the 1 year or 2 years. It's also advisable if it's the lawyer who issues that notice.
So even at the point where you have noticed a damage, before you take delivery, you can contact your lawyers immediately and have them initiate the process of compensation for that loss or damage. by issuing the appropriate notice as the law would require. And I think this is a very good point to just reiterate some of the things that Lucia have said. Act fast, be decisive, notify in writing, and of course, talk to your lawyers and get the appropriate advice that you require.
We have more of this in the works, and we really look forward to your comments or your feedback or your questions, whatever inquiries you may have, and you can also call us, and we're always ready to talk to you. Thank you so much for joining us, and it's been really interesting, and we look forward to the next podcast.
Episode of 45th. God bless you.
Thank you.